For example, if in a city where there are 4 benches in the NCLT, and 2 benches are only hearing company matters, 2 benches are only hearing IBC matters, then it's worthwhile changing.
Because then it will be an unwieldy little thing. It now with AI and with blockchain, it should be integrated. Now, for instance, you still require a certified copy in order to file an appeal.
It's not just the members. We often read in newspapers or in Supreme Court judgments as well.
And this was during the second wave of COVID. It had just come out of the first wave. It was during the second wave, and it was not full-fledged physical.
Just to change the combination of judicial member and technical member, there's no point to changing it.
How does it impact you and your clients? How do they see frequent transfers of the judges or the short tenures of the judges?
So, it's not as complicated because it's one tribunal. It's not complicated like, the state judiciary where you have to consider a lot more issues. So I don't understand why, somebody can't just sit and revise these rules from time to time.
What distinguishes a well-functioning bench from one that struggles to inspire confidence?
Every litigant and lawyer wants to feel that they've been heard. So they should not come away thinking that I have not been heard.
Welcome to the DAKSH podcast. My name is Ritima Singh and I'm your host for today. I work at DAKSH, which is a Bangalore-based non-profit working on judicial reforms and access to justice. This year marks a decade of the Insolvency and Bankruptcy Code. Much has been written and spoken about the recoveries, resolution plans, timelines, creditor rights. But behind all these stands an institution that has received far less attention than it deserves, the National Company Law Tribunal, NCLT. Interestingly, the NCLT's story did not begin with the Insolvency Bankruptcy Code. The idea of a specialized company law tribunal had been discussed and debated for decades. It was envisioned as a forum to deal with company law matters more efficiently and with greater expertise. However, as India grappled with mounting stress, assets, and the need for a consolidated insolvency framework, the IBC designated the NCLT as the adjudicating authority. In doing so, it fundamentally transformed the institution. What had been conceived as a company law tribunal suddenly became the institution at the heart of India's insolvency ecosystem. 10 years later, we know a great deal about the code has performed. Equally important, however, is understanding the journey of the institution that has been central to its implementation, that is, the NCLT. To help us think through this, I'm joined by two guests who have seen the NCLT from different vantage points. Mr. Rajasekhar V K, he's a former NCLT member and has sat on the bench and watched the institution function from the inside. Mr. Harish Narasappa is a senior advocate who has appeared before the NCLT for years, observing its evolution from the other side of the table. This is meant to be a candid, reflective conversation, not a technical breakdown of the insolvency law. We want to understand the NCLT as an institution, its strength, its limitation, and what the future holds for it. Welcome to the Daksh podcast. One of the most enduring debates about IBC has been the role of NCLT. The IBC ecosystem envisages various actors, be it resolution professionals, the adjudicating authority itself, or the committee of creditors. However, the uh, the line between where one actor stops playing and where the other actor resumes the role is slightly blurred. So, Rajshekar sir, having served inside the institution, what do you feel is the line, or is there a line? Because there's a constant debate about role of NCLT as a limited supervisory authority versus NCLT is pushed towards a more adjudicatory role.
We must, in order to answer this question, go back to the first principles, which is to be traced from the BLRC report. So, the BLRC report is what makes this clear distinction in roles between the resolution professional, the committee of creditors, and the adjudicating authority. So, when the law came about, Parliament actually differentiated these roles quite clearly. But in practice, you cannot really have a visible, thick red line saying this is the Rubicon which you will not cross. It will always bleed into the other's role. The trick is in ensuring that it doesn't blur so much that it makes it completely indivisible. So that is the role. So if you see the role of the RP first, the RP's role is as the custodian of the process itself,
Correct.
and the role of the COC is to make all the commercial decisions, and the role of the adjudicating authority is to ensure that these decisions are fair and transparent to the extent possible. But in reality, having seen how it has progressed over the last 10 years, even the BLRC could not have envisaged certain situations which are more or less completely judicial in character.
If I can
Yeah.
add a few points, see, I have just a slight difference from what Mr. Rajasekhar said. See, if you look at the code, forget about what the intention was. If you look at the core itself, there are two distinct roles for the NCLT when it comes to the process, the insolvency process. Now, there are certain powers that the NCLT has, um, avoidance transactions being the
Sure.
main set of provisions, undervalued transactions, preference transactions, fraud, all of that, where the NCLT has a clear adjudicatory role. Okay, that is not a supervisory role. That is actually
Yeah.
adjudicatory in character.
Hmm.
But and then there's the admission, the initial admission
Correct.
of an application for CIRP. Okay, but between admitting a company into CIRP and until the resolution plan is approved or it goes into liquidation, that period, I think that is more of a supervisory role. And then the adjudicatory role is distinct, where if certain transactions are pointed out as preference or undervalued or whatever, in connection with those powers, neither the RP nor the COC has a role.
Absolutely.
They can't decide, correct. But because, I think what has happened is because the NCLT is a quasi, judicial body, I mean, it's a tribunal. So I think the instinct is to rush to it for everything, right? For example, why should the RP go on so many applications to the NCLT in respect of what he is supposed to do? Why should he file those applications?
The procedural updates.
Right? And an update, okay, you want to, because there's a timeline in the code, you say, okay, why you're not able to meet the timeline. So you want to keep the NCLT updated, but predilection to file application and after application for the resolution process, I think should stop in some form. And I think that we need to, so the law needs to be laid down. I think it's not clear, right? If you put yourself in the NCLT shoes, if a question is asked, they have to answer. Okay.
Correct.
Now they should answer saying, "Don't come to me at all. Why are you coming to me?" No, but that has not happened. So because somebody then they issue a notice if one person makes an application or they say approved. Um, it may happen. It may have happened for one more reason, that because it was a new law, the RPs and the COC also may not have known how to proceed on certain things. So they wanted clarification. And there is this impression that, okay, if you get blessing from the NCLT, then everything becomes kosher.
Yeah.
Okay. I think that mentality needs to go.
Just to supplement what he said, in the case of the CIRP itself, there is actually no provision in the code for filing a progress report. It doesn't ask for it.
Correct.
Unlike in liquidation, which the regulations prescribe should be there should be a quarterly progress report before the adjudicating authority. There is no provision in the CARP regulations or in the code to file progress reports in the CARP. But yet, somehow,
It's
a
happening.
practice has developed, and that convention instituted from the principal bench has now percolated across the other benches, and they ask for progress reports. And from my experience on the bench, I can say that these progress reports are hardly read. But they're still, it's
Right.
still a job to actually take it on record and record it in the order.
Compliance now it's become
It is not even a compliance because there's no
provision for
framework or a
yeah.
provision under which you are going to file it.
It's just taken on record.
It is just taken on record. And for this, you need an IA now.
Exactly. I was looking at the type of IAs. So far, I've been able to identify 45 type of IAs in IBC. And these are mostly we have done this, we have done that, we need extension, we need appointment, we need this and that, which I feel could be streamlined. Okay. So on that level, this is debate about the powers of NCLT. But institutions are not judged by the powers they possess, but exactly how they execute it. So whenever we go to a practitioner and we ask them about what do you feel about this institution or what do you feel about this about NCLT, a practitioner's response will never be oh this judgment or that judgment. It will mostly be how is predictability established in that institution? How is certainty? How much certainty is there? Feel heard. So business is all about certainty. Investors want certainty. The process, CIRP process itself wants certain level of predictability. So from a practitioner's perspective, so what distinguishes a well-functioning bench from one that struggles to inspire confidence in the litigants?
But so there are two aspects. One, every litigant and lawyer wants to feel that they've been heard.
Correct.
So they should not come away thinking that I have not been heard and they were not fair. So that's that's the basic requirement. Second, the order should reflect the fact that you have heard the parties. Correct. Uh, so I think that's all we look for. I mean,
But-
there's nothing, there's no greater expectation than asking people to hear you and record what they have heard and give an explanation as to why you're rejecting an argument or not. I mean,
Okay.
that's all people expect.
But what if we talk about on institutional level and not on bench level? So, for example, if we go to this tribunal, there is certain level of certainty, predictability, and there is a course to it.
Correct.
However, if we forum shop and we go to this high court, suppose there is more level of certainty. Do litigants think this way?
See,
In terms of NCLT
no,
specifically?
no. I think, see, across our judiciary, there is a problem of event certainty on any given day, right? And it's the same with the NCLT. So
Okay.
if your matter is listed for hearing and you turn up there, you don't know whether your matter is going to be taken up. That's the first one. Because there may be 50 matters, it may not reach. It may, and if you're number 50, I mean, the chances of it reaching or not reaching are equal. Okay. Then B, even if it reaches, whether it will be heard. Why? You don't know. You may be ready. The other party may seek time. Both of you may be ready. The bench may say, listen, we have not been able to read, or we don't have time today, or this matter requires like 2 hours of time, so we will hear you on some other day. So the lack of event certainty on any given day, but that's same across all
That's
courts in the
uniformly
country.
for all judiciary.
Okay. Now, in the NCLT, and I'm talking as an institution across the benches, um, why does the NCLT suffer um, a poor reputation? Is because it's not because of any particular time. I mean, if you ask me, I mean, I practice mainly before the Bangalore NCLT. If you ask me currently, nobody is complaining that they're not being heard.
Yeah.
Okay. But in the past, there have been instances where, for months together, there was no bench. And there have been instances in some benches of NCLT where suddenly one member just gets up and leaves in the middle of the argument, right? Arguments are going on, one member just leaves and just gets up and leaves without any explanation. And then the other member says, no, you can continue, he'll come back. So some of the points that practitioners used to make earlier, and this may vary from time to time, it may happen. That is because of the nature of recruitment in the NCLT. What many practitioners call judicial decorum, right, which you see, generally in a civil court or in the high court. Many people felt that at different points of time, this concept of judicial decorum was lacking in the NCLT, right? And it's not across. I mean, there are always exceptions.
Absolutely.
Mr. Rajasekhar is here. Now, why that is so? I think maybe because when the NCLT was initially set up, maybe because maybe there wasn't enough time spent um, on
Designing and curating.
no, more than designing, training of the people, right?
Yeah.
In terms of how one behaves when you're sitting as an adjudicator. Okay, there's certain decorum, there's certain seriousness, there's a certain stature when you're deciding something, because there are parties coming before you, so they're looking at you to decide something.
Yeah.
In a fair manner. And the nature of the judicial process is it's an open process, right? Anybody can come in, watch, whatever. So there is a certain dignity of behavior expected by everyone involved, including the lawyers, right? You can't have lawyers behaving, badly, and that I think was not done initially. I think it's getting better, but I think it was not done initially. But that reputation, unfortunately, has stuck because of this reputational issue of how the NCLTs functioned during the initial period. I think that seems to have stuck. So that needs to be corrected. But I think that's a matter of training of the officers who are appointed as judicial members and technical members, because the technical members may not come from a legal background, they may not have seen how courts work, and even judicial members, some of them may not have practiced in courts for long, or even if they have practiced, they may not have been adjudicators. Having been a lawyer for so many years doesn't make you a good judge on day one, right? It requires work, it requires training. And if you look at how different states train civil judges, fresh civil judges, they spend 3 to 6 months going through a rigorous training process, including how to behave as a judge, because you're dealing with the public and it's a question of inspiring confidence. And I think maybe that needs to be done. I mean, I'm not saying it's not happening, it is happening, but it's not sufficient. And when your recruitment process is not done properly, in the sense that if there's a vacancy, then you wait till the last moment to recruit someone, then you don't have the luxury of this training period.
Absolutely.
Okay, you recruit and then you put them on the bench on within
That
like
window
1
is
week.
gone.
Within 1 week,
Yeah.
that, I mean, then you're being unfair to the people who are sitting on the bench also.
Yeah.
And I think that's the point that we should remember.
So your thoughts being on that side of the table.
Again, to some extent, I would differ with Harishji, but in most of the cases, most of the points that he has made, I would agree with him. Just as there is courtcraft which is recognized amongst practitioners, there is also something of a courtcraft that the judges must themselves have. For instance, how to control the court, how to control the proceedings, and to the extent possible, complete the cause list every given day. Because it is not always that you will have people who are practicing in the same city who are appearing before you. You are a national tribunal, with the result that the entire process has to be conditioned towards recognizing the fact that you will have people who may be coming from outside your state. So the cost list, as per the rules, is supposed to be uploaded on the website by 6 o'clock. But it wouldn't happen. It wouldn't happen because I can speak from personal experience. If I am sitting in one court from 10:30 in the morning till around 2:33, taking a small break, rushing to another court, sitting there till 6:37, the cost list cannot be uploaded until it is shown to me. So they wait until the members come. then you have to see what orders are ready for pronouncement the next day. This is from a perspective that is an insider's perspective of things. You have to see what orders are ready for pronouncement the next day, put it on top of the list. You have to see the supplementary list that comes through, that is the fresh matters that come up. Which of these are urgent? Then put them on the cost list, and then put your regular matters which you have already stated will come up on that day. So, on an average, any given bench deals with around 80 matters. So, when you have 80 matters, and if you know that every day you're going to deal with these 80 matters, on an average 75 to 80 matters, you should at least mentally make up your mind as to what matters you'll be taking up and then allocate time accordingly. So, let's say you have the first matter, which is a matter scheduled for arguments. You have 10 other matters where only the process is required to be completed. Then it becomes a judicial temperament issue to see that you don't keep the 10 people waiting because you have to take up this item number 1, which is for arguments now. Because the other 10, if you release them, one, you have a leaner court, your cost list has reduced to that extent. You'll be able to devote much better time to listening to what the arguments are, because there is less of a disturbance in court. So these things, sometimes you grow into the role. Some people grow faster. Some people take their own time to grow into that role. Each of these requires, like Harishji said, a little bit of training, but you cannot actually condition them into doing it, because it is a sense that you get when you sit on the chair that these matters will take so much of time, so I'll need to allocate so much time for this. This is the total time at my disposal, and therefore I'll have to finish the rest of the board, not keep discharging the board each day.
Correct.
That is one. The second, we can make do with certain useless interlocutory applications that come up on board. We can, in fact, delegate these to the registrar, because, for instance, the CARP progress reports, you can either eliminate them altogether or you can give it to the registrar, enabling you to look at it administratively only when there is an issue to be looked into. Now, how the COC is constituted, for instance, is a matter entirely left to the RP, because he is basing it on the claims of the financial creditors. Now, if there is a complaint, then it becomes an adjudicatory process now. Only then do I have to come in.
Absolutely.
Not otherwise. Otherwise, I don't need to know if there are 28 members there or 30 members there. It makes no difference to the process. So these things must be addressed at the tribunal level, not at a bench level.
Absolutely. Yeah.
So once these are addressed at the tribunal level, you'll have probably a leaner cause list. That is one. Second, with sufficient training. Right now, you don't have the luxury of giving them a 2 or 3 week training. So, with sufficient training, or at least getting them used to court experiences, they'll be in a better position to discharge their responsibilities. And the third is, sometimes, like Harishji said, you may be mentally fixed and come prepared to hear a particular matter, which is probably a fixed item on the board. That particular day, the senior counsel engaged for that matter may be busy somewhere else. He or she may not make it on time here, with the result that it creates some kind of a ripple effect on the rest of the matters in the board. So you have to adjust the time slot accordingly. But again, having said all this, as long as you go to a tribunal which is having an adjudicatory role, and you come back feeling that you have said everything that is there to be said as far as your client is concerned, you will not be unduly concerned about which way the order goes, and if your arguments have been treated in the order itself. So,
Correct. So it's a craft indeed.
it is a craft, uh, just as it is a craft to be able to present yourself in court from a practitioner's perspective. It is equally a craft to include in the pleadings what is to be included, and to keep certain matters only for arguments. It is equally a craft to be sitting on the bench and deciding matters.
Yeah.
Not everybody is gifted with that temperament, and that is something that the selection processes must also recognize. Like Harishji said, a great counsel need not necessarily make a great judge. On the other hand, a completely average counsel may make an outstanding judge.
If culture shapes credibility, and the next thought that we have is who should be entrusted with this culture. So Rajsekhar sir, uh, you've been a member in the NCLT, and you know the ups and downs, and you know what needs to be there to sit on that bench and to do justice to it. So who should actually be appointed in terms of both judicial and technical members?
It's a very controversial thing, but still I'll say to the extent that I'm I'm okay with saying it in a forum like
Absolutely,
this.
absolutely.
There's nothing wrong with the with the code or uh, with the Companies Act provisions that deal with recruitment of members. So you must understand that the NCLT was originally not designed for the IBC.
Correct.
It was designed for company law matters, and that was an adjudicatory role, with some being a supervisory role, like the schemes of restructuring, amalgamation, demergers, etc. So primarily, it was concerned with investigation matters or with operation and mismanagement matters, rectification of register, which can be called adjudicatory functions in their own right. The NCLT was something that came to be thrust upon
Yeah. Overnight.
the IBC. Sorry,
Yeah.
was something that came to be thrust upon the NCLT. The original strength was 63, 62 plus
Absolutely.
one president, meant for company law matters. Now you are faced with a torrent from the IBC, which, because of its strict timelines, practically overtook company law matters.
Yeah.
Now, if you look at the the statistics, it may seem very rosy, but one must look at where the adjudicatory company law matters are actually coming from. That, if probably you have a differentiation, you will know that that has completely lagged behind when compared to the IBC statistics. When you say so many company law petitions have been disposed of, company law applications have been disposed of, they mostly relate to either Section 252 matters, which is restoration of name of the company, or they look at schemes. But if you remove these and look at what is
Pending.
investigation under Section 213, how many orders have been passed, or if you look at the Section 241 matters, how many oppression and mismanagement matters have actually been decided and within what kind of a time frame, that will give us a better perspective of what NCLT has done with its original mandate. This is actually now, because if you don't do it today, tomorrow you are faced with this plus X matters which are
Correct.
slated for tomorrow. It's that pressure that is also telling on the members. It is also telling on the registry. It is telling on the overall infrastructure, and it is also telling on the adjudication. We cannot actually be blind to the fact that many of these matters are not adjudicated in the way they should probably be adjudicated. And this is because of the pressure that this IBC system has created. So I have long advocated for a national insolvency tribunal or expand the current
Strength.
number of members, number of benches, or have specialized benches deal with this one. But probably that is a minority view. Harishji said, this sense of time, it is not relevant just in the context of insolvency. Insolvency, of course, it is relevant because unlike in other disputes, in the case of insolvency, it changes it not only changes the nature of the process itself, it changes the commercial dynamics of it all. Now, if you remember the Bhushan Power judgment, the appeal in the Supreme Court came to be filed in 2019.
Yeah.
The first set of decisions that came in 2025 May.
Correct.
In the meantime, 45 hearings had taken place. And that's a 19,300 crore matter. Not a small sum in
Absolutely.
today's context. By the time the matter came to be decided, the whole plan was implemented, done, dusted.
Yeah.
And so, in spite of an assurance given to the highest court of the land that we will abide by the appeal, and in case the appeal succeeds, we will refund the money, they were in no position to do so because it had changed the nature of the economics involved completely. Similarly, you have a situation in the IBC also. You have a person challenging the appointment of a financial creditor on the committee of creditors. He says he has no business to be sitting there. And if it takes 1.5 years to decide that, then what happens to the decisions taken in the interim and in appeal?
Correct.
What happens to all those? It is possible that he may be in a position, if the appointment was wrong, he may have been in a position to influence the resolution plan outcome itself. What happens then? These are all purely not supervisory roles, but these are really hardcore adjudications, and you need people who understand this before you put them on the
And
on the
hardcore,
tribunals.
quick adjudication.
Quick adjudications,
I think you have
because
to
the
decide.
commercial effect of that has to be understood.
Yeah.
You decide today. And given the way the NCLT is functioning now, every application is served in advance, right?
Yeah.
So then you decide then and there. At best, you hear it one day later. Yes, the problem is now the pressure of the docket is very high, but it's our own doing, and we have to resolve it. I mean, if it means that we need to appoint additional benches, we should. See, you're not dealing with the regular district judiciary where there are 24,000 judges across the country. I mean, you're dealing with a very specialized tribunal, and it is not rocket science to decide how many benches you need to have and what should be the capacity. Mr. Rajasekhar was referring to, if I'm sitting on one bench or another bench, why should he be sitting on two benches?
But it's a very common practice.
That's what
Yeah.
that is unacceptable.
Yeah.
See, we can't accept just because we have done something in a particular way to tide over an emergency situation because one person is sick, one person has retired, whatever. That should not become the habit.
Norm. Yeah.
Where you're saying, okay, now the judicial member in city A is retiring, so judicial member in city B will also act in in that bench. I mean, it's I mean, it's criminal, right? You can't let commercial tribunals suffer from lack of appointment in time. So when you're dealing with as basic as that, as appointment on time, now we're talking about culture. Then it's a
Yeah.
we are at a far more basic level than see. And if it's this goes to culture, right? If you're
Yes.
in every day there's a culture of, in half the matters you're seeking time to file hard copy, in half the matters you're seeking to file
Correct.
to something else, and if you keep allowing it, that's the culture of the tribunal then.
Yeah.
Whereas if you want it to become a smooth functioning tribunal, then all these other issues you thrash it out with the registry, right? Whether you want to file hard copy, physical copy, sorry, e-copy, you want to file two more copies, whatever it is, why should it be
Members'
something
problem,
that the bench needs to spend judicial time on? It need not be. So this goes into the culture, and now we have to undo some of these
Yes.
practices that have crept into NCLT. And it's same practice that happens in other courts as well, so it's not unique. But because it's the premier commercial tribunal, we have to make an effort to correct this culture, because again, as I said, the bar is a small bar. The commercial bar across the country is a small bar. It's not a very large bar. Okay, so and it's easy to build that culture, but we are not making enough efforts. The interaction, for example, between the NCLT benches and the bar is not, doesn't, rarely happens.
It
right?
doesn't happen.
Doesn't happen. There's no NCLT, but I mean, at least in the high courts, there is some interaction, right? You don't see that happening here in the NCLT. So we need to do something to fix this. And because it's a small, it's a reasonably small community, it is something that can be fixed.
But there is a bar in Delhi, NCLT.
there are
Yeah,
bars
there are bars,
everywhere.
but what do they do?
Oh.
I
But
mean, do
there's no
they
interaction
interaction with
except
the
for,
yeah?
I'm sorry, sir,
Yeah, go on.
except for receiving members and sending them off.
Protocols.
In the sense,
Yeah.
No,
the
welcoming
function,
them when
welcoming
Yeah,
them,
somebody takes
yeah,
charge, and then saying
yeah.
bye
and
to them
saying
when they
goodbye to them.
retire. But this
So,
so
other than that, there's
hmm.
nothing that is happening. I have not seen a single bar association rake up issues that must actually be raked up during my time on the bench. It may be happening in Delhi, but in the other bars, I have not seen it happen. Maybe you have a different perspective,
I
but
mean,
I have not seen that
there is
happening.
some, but it's a very let me put it this way: it's very stilted interaction, right? I mean, and I don't blame it. I mean, you need once you are on the bench, you need to make sure that you're sufficiently uh, aloof from the bar. But it doesn't mean that on issues that concern the functioning of the tribunal, there should not be interaction. There should be interaction on how to make this tribunal better, and that's part of the culture, because culture is both the bench and the
Correct.
bar, right?
The
It's not,
responsibility is
yeah,
equal,
is
Yeah.
correct?
equal. So if the bench also should say, why are you coming and doing all this? Why do you need to file so many
Yeah.
copies?
I'll give you an anecdote. One day I finished court at 9 in the night. I had 3 courts that day. I finished the cost list in all 3 courts. When I came out, I had a long list of young advocates who were waiting to see me in chambers. I said, why are so many people waiting at 9 in the night? So I said, call them in. So they all came in. One of them had an issue with the registry. The issue was in a section 59
Hmm.
final report, IBC. He had filed the report. The registry had returned it 3 times, saying there is no service on the respondent. Now he says, I've got tired of telling the registry there is no respondent in a
Respondent.
section 59. Now, where can I produce the notice of service from? So I had to call the registry
My
people and
God.
say, get this numbered. These are matters, and that day I went home at 10:30 in the night. So these are some of the things that we are
Yeah.
forced to handle, and that because you have not built a dedicated NCLT tribunal, not NCLT. In fact, you can take it to be any tribunal for that matter. You don't have a staff of their own.
Yeah. Which brings me to my next thought. Like, it's not just the members. We often read in newspapers or in Supreme Court judgments as well, but a lot of their performance depends on the institution's ecosystem, the staffing, the resources given, the service conditions. So, you have, sir, been on the bench. What are your thoughts?
Where do I even start? That is the question. We talk about this ecosystem, and you spoke about the quality of the filings that are made. That they have to reduce the quality of the scanned copy only so
For
that it
it ought,
fits into this
yeah,
system.
upload.
Otherwise, it will not
Yeah,
accept it.
correct, correct.
Now, because of that, even if you expand it on screen, howsoever big your
It's
screen
it
is, it
can't
is
be
impossible to
yeah.
make anything out of it.
Hmm.
That is one. Second, when I went to Calcutta, we had a network which was, I think, 5 Mbps or something. And this was during the second wave of COVID. We had just come out of the first wave. It was during the second wave, and it was not full-fledged physical hearing yet. And the first thing I noticed was that the court master would only allow the person whose matter is being called into the virtual courtroom. So I said, this is not done because it's
Yeah.
supposed to be an open
Yeah.
courtroom. If it is a physical hearing, you would allow everybody in. Why don't you allow everybody in? He said, sir, the network will not support us. With 5 Mbps, it had to be shared by the court, by the LRAs who are sitting there in their seats listening to the arguments so they can take notes, and by the counsel. So it was impossible. So they had to restrict it. And so when we wrote to headquarters saying, please get this done, we'll increase this to 48 Mbps, which BSNL was willing to provide. The first question that was asked is, every other bench is able to do it with 5 Mbps or
Yeah.
6 Mbps. Why does Calcutta alone deserve more? So this is part of that system where you enable certain things to be done in a certain manner. It's not just window dressing in the form of, say, e-court system. We have it fully functional. You answer Parliament. You must see how efficiently it
Correct.
functions. It cannot be built patch by patch, because then it will be an unwieldy little thing. It now, with AI and with blockchain, it should be integrated. Now, for instance, you still require a certified copy in order to file an appeal,
Yeah.
right? NCLT rules say that after every order is passed, pronounced in court, a free copy will be served to the parties. It's only the others who have to apply for and obtain a copy. Now, what is the difference between the free copy served over email and the certified copy given by the registry?
The charges.
What is it for? Then why are you serving a
Yeah.
free copy?
And it varies.
Can the order be different?
Yeah.
If it can't be different, and one can understand, you have 30 days to file an appeal, 15 days condonation. NCLAT cannot do it beyond that period, and you are seeking condonation of the time spent in pursuing the certified copy. One can understand that. But what if I am filing it within 2 weeks? Why can't I file it with the same certified copy? I don't understand this process at all. And in the case of this physical copy that you mentioned, when I raised this question, the answer that I was given is because the NCLT rules permit it. The NCLT rules require it. I said the NCLT rules will require the number of persons sitting on the bench plus one extra for the office copy. And if you do this, the building that we were in NCLT Kolkata would collapse, because that was certified dangerous by the local PWD.
See, and the second point is the NCLT, if you're accepting all e-copies and the orders are also available online, then why produce another physical copy to NCLAT? You just give the case number of NCLT and let them pull out the records. You know,
And
some things, just defeat me. I don't know.
And we had a special bench in Mumbai to clear just the scheme matters at the height of COVID, when everything was under lockdown. And so it was a simple matter of prudence that even if we pass the order and upload it, the registrar will still not accept it because it is not a certified copy.
Okay. Bureaucracy.
He can't say, because the form asks for the date of certified copy, etc., etc. We had to pass a judicial order directing the registrar to accept a digitally signed copy, because both members were sitting there in their respective places and digitally signing it. Once it is digitally signed and uploaded, what is the effect of having a certified copy now of that?
See, and this doesn't require legislative change. It requires rule change by the NCLT and the NCLAT themselves. So, it's not as complicated because it's one tribunal.
Correct.
It's not complicated like, the state judiciary where you have to consider a lot more issues.
Correct.
So I don't understand why, somebody can't just sit and revise these rules from time to time. No, nobody is doing that.
Certain things can be done even at an
Administrative level very quickly.
A notification. That's all. A certified copy or a digitally signed copy should be perfectly
Deemed
acceptable.
admitted. Yeah.
You want to verify the veracity, it's there online.
No, and anyway, it's an adversarial process. The other side will point out if you are, trying to give a fake copy.
Yeah.
It's unlikely, and it's your own. It's your own system. It's your own system, right? I mean, this is like, even like in the tax litigation, if you are saying, if you're uploading the assessment order and that assessment order is being appealed, why do you need to file another copy? I mean, it's on your system anyway. Why spend so many crores of rupees on digitizing the whole system and then refuse to use it to the full extent?
Correct.
And insist on paper all over again?
Anything about the service conditions or the infrastructure? We all know it's quite a problem.
We have discussed it rather elaborately, though we need not have, but we had to go to that level now.
Okay, so we'll move on to the next question I have. So, appointment is assuming the appointment is excellent, staffing is excellent, but in terms of continuity of the bench, few frequent transfers, short tenures, sir, how does it impact you and your clients? How do they see frequent transfers of the judges or the short tenures of the judges? Does it impact the case?
Of course it does, right? Of course it does. I don't have a problem with, sort of reorganizing of benches, from time to time. It does bring in, a different perspective. But only if there is a change in the nature of matters you're hearing. Just to change the combination of judicial member and technical member, there's no point to changing it. For example, if in a city where there are four benches in the NCLT, and two benches are only hearing company matters, two benches are only hearing IBC matters, then it's worthwhile changing, from time to time, just to give some sort of. And I would like to hear what Mr. Rajasekhar has to say from sitting on the bench time. Would you like to hear different kind of matters for some time, etc. And also, to break the, maybe one particular judge is not being, sort of very sensitive to what's the topic, or is not able to, appreciate all the issues, and it's worth changing. So it brings an element of, freshness, and, even for the lawyers concerned, they can argue the case better, etc. So per se with transfers within the NCLT, I don't have too much of an issue, right? My concern is more with how long are you appointing each member for, right? Are you only giving terms of 3 years, 4 years? I think that is a problem. So if you're giving a 3 year appointment or a 5 year appointment, and in that time you're transferring them around, I think that doesn't, it neither gives security of job for the people on the bench, nor does it give security for the bar.
Yeah.
Right? Because also if you're arguing a very heavy matter, say an operation and mismanagement, and the there's going to be a transfer in 3 months, then how do you know the person is going to write the order before he is transferred?
Correct.
Right? Then you have to argue the matter all over again before another bench.
Continuity is the problem.
Continuity, no. So I don't have a problem if different stages are heard by different people. That's not the issue. The issue is on decision.
Okay.
I hear, I sit on a particular roster for say 4 months, and there are 10 heavy matters. So I hear two matters thinking that in 4 months I'll write, two judgments and go. Whereas if you know that you are there for 1 year, you may hear all of them.
Correct.
Right? So I think there's a roster change and transfers happen to ensure that there's not too much comfort between the bar and the bench. That's the reality. You don't want to encourage other sorts of problems. I think that's why it happens, at least in the judiciary. In tribunals, given that it's a much smaller number of people we are dealing with, the room to play around is less. Okay, I mean overall, if you're looking at 63 people, you're looking at basically about 100 individuals across the entire country at the NCLT level. Then it should be an easier method, or easier ecosystem to manage, right? If you have, if there are sometimes in one city the members of the bar don't get along with one individual, right? Then there's protesting, transfer him, transfer her, whatever, right? Then how do you deal with those scenarios? So I have less of a problem with that in terms of transfer. It's okay, but don't do frequent transfers, right? And don't create uncertainty by saying, members sitting in Chennai will also hear Bangalore matters. Members sitting in Indore will also hear, Ahmedabad matters. Don't create that sort of uncertainty. Okay. As long as there is certainty about transfers, if you know there's going to be a transfer once in 2 years, at least that should be clear. Publish the policy, right? In the district judiciary, at least, it's very clear that there will be a transfer unless other things change once in 3 years. 3 to 4 years, there will be a transfer. Then everybody is prepared for that, so everybody knows how it goes. So it's an open book that way. In terms of time a particular judge spends in a particular court. So if you want that kind of a system, you do it. Otherwise, I don't particularly see why there should be constant transfers in the NCLT benches. I don't see the need for constant transfers. I mean, I would like to
Yeah.
hear from him. I don't know what the reasons for transfers in NCLT are, but
So both transfers and tenures.
I'm sorry, but I'll have to completely differ with you on this. Reason is in 2019, you have what is called the NCLT salaries, remuneration, and other terms and conditions of service of members rules. So that did not actually specify a tenure when it was originally
correct.
brought on the statute book. Then on 23rd of September 2019, Rule 15A got inserted into the rules. Now, of course, it has been placed before Parliament, it has acquired the force of law. Now, Rule 15A says that the original appointment of the member concerned will be made by the central government.
Correct.
Okay, the place of posting, not the particular bench within that, where you have multiple
Basically, the
benches,
So only the
location.
multiple,
city location
yeah,
is
The
the
not.
location will be decided by the central government. The actual court which he or she will handle will be decided by the president. The constitution of the courts will be the president's prerogative. The initial posting is the central government's prerogative. And that rule also says that a member once posted will be there for 3 years unless there is some administrative reason to transfer him or her.
Okay. And the transfer is through central government or the president?
No, I'm coming to
Okay.
that. So the normal tenure, once you're posted to a particular city and the bench is constituted, there could be a reconstitution of benches within the city, but the tenure of that particular member to that particular city is more or less fixed for 3 years unless there is some administrative or consequential reason. Say by virtue of retirement, somebody else has to look at one more bench or he is transferred because of that. That being a different issue. Then there are certain other considerations that apply. That the rules also state, the 15A also says that if you have come from practice, whether it is as an advocate or as a chartered accountant or a cost accountant or a company secretary, then you will normally not be posted in the same place
Same.
where you were practicing or where your near relatives are practicing. So it will normally have to be outside. So the consequential transfers take place only because of retirement or a resignation that has come about. Now, then, why do these frequent transfers take place even though the rules do provide for it? No, they happen because at any given point of time, the strength of the NCLT is not more than 60%.
Sadly, yes.
There's been a very, very narrow window when you had the entire complement. That was in 2025, January, 8th of January, when they made the postings. They factored in retirements that would happen until 31st of March 2025.
1 month, 61 members.
Yes.
Yeah.
That was the only time you had the full complement of members. Otherwise, you were making do with 28 members, 30 members, manning all these benches.
Yeah.
So, invariably, if one person were to retire, he has to give a notice period of 3 months. Within that time, ideally, the member concerned should dispose of all the matters heard and reserved by that particular bench. Because the retirement of one person will still disturb this thing, and you have to de reserve the matter and hear it again now. But within the same jurisdiction, transfers don't take place that frequently, unless, as I said, there is a consequential change that has happened. Now, this policy is there, it is in the rules, it is notified in the Gazette. Okay, so this situation may not have this, the ground reality that we are seeing today may not take place if you have the full complement of members. But that again is dependent on so many other factors. So that is the reason. It's very rarely that a member requests that you post me in a particular place. It does happen. I'm not saying it doesn't. There may be medical emergencies. There may be family emergencies necessitating that transfer. But transfer on that ground alone happens very rarely. So within these 3 years, if you have to transfer as per the original thing, then you have to get the concurrence of the
of the person.
Central government.
Central government.
For transferring that person beyond that jurisdiction. It normally doesn't happen.
Okay.
So actually, I don't know how. I thought we are both saying the same thing. I thought.
No, you are saying that you wanted a policy. There is already a rule. It is published.
No, so I am okay with.
And why this happens again, I am telling you, because if you recruit at 60, then you would be able to give him a tenure of 5 years.
5 years.
Now, except for the original complement of members, the 16 judicial members and around 15 technical members who were appointed originally, nobody else has been in a position to complete 5 years.
Yeah.
That is the reality.
2 years.
Practically
or 3 years.
speaking,
Yeah,
yeah.
yeah, yeah.
No.
So 3 years is what they get.
No, so
Yeah.
I agree with what Mr. Rajasekhar is saying. See, in a 3-year term, I don't think there's any need for transfer from one bench to another bench, if that was your question.
Yeah.
In one location, rearrangement of benches again should not
It
lead
normally
to
should
too
not
much of a
happen, and
problem.
because
But
again that creates an issue.
it creates an
Because-
issue in terms of judgments and other
Yes.
things. And then every sitting then becomes a special bench. Then it becomes a problem. So if it's managed well, it's not an issue. It happens in high courts, for example, all the time. But 3 years, there should not be any transfer. And the only reason transfers are happening, as he pointed out, is because some benches don't have any members.
Correct.
Yeah.
In other cities. So it's not as frequent as people think it is happening. I think where the period before 2025 for a year and a half, that was chaos because there were not enough people. And there were too many.
And in 2021.
2021, yes, just after COVID, there was chaos, and just before 2025, there was chaos. In fact, I think there was this rather comical scenario where I think every few weeks there was a new president for some time.
Every day.
Every day.
Interesting.
That was middle of 24.
Between 1st of June and 9th
correct.
of June.
Yeah, there was a new president almost
year?
every other.
Which year?
2021.
2021.
There was a new president almost every other day.
Nice. Okay, so we'll end this conversation on a very forward-looking note. We have discussed about legitimacy, certainty, appointments, NCLT's culture. If you were to give few recommendations to policymaker or their to-do list for the next decade for NCLT, what would that be? We can start with you, sir.
First, increase the number of members.
Yeah.
Recruit them slightly earlier than what you're actually doing.
Yeah.
Because if you can be a high court judge at, say, 45, why can't you be a tribunal member at 45? But this has a 50 thing. But I still am the youngest ever who was appointed in the NCLT. But there are about maybe 5 or 6 people of maybe my age bracket who would have been appointed, because the rest of them have gotten appointed at around 58, 59, 60 years of age. And most of the appointments happen because, especially in the case of technical members, they get appointed after their retirement, which means by the time the process is completed, they would have a they would have a tenure of around 3 years left.
Yeah.
Because if they apply at 60, the recruitment process itself takes 1.5 years. On an average, it takes 1.5 years. So if you recruit people, if they apply at 60, they get appointed at around 62, which means they are left with a 3-year tenure.
Yeah.
And this is exactly what Senior Advocate Arvind Dattar argued in the Madras Bar case. Saying giving too short a tenure is not good for the institution. So minimum tenure, in fact, the judgment says 5 or 7 years. That should be the minimum tenure. And still it doesn't happen. In reality, it doesn't happen. So maybe that you address. And second, the build up a core registry and the back office support staff who will actually be able to deal with the registry issues. The third I would suggest is of course, the number of members we have already spoken already. So number of benches and number of members. You also create a specialized set of benches to deal with certain matters.
The law or certain kinds of matters? So, like specialized
Certain kind of
bankruptcy.
matters.
Okay.
Certain kinds of matters. Like, see, uh, for example, dealing with resolution plans. If you have multiple benches within a city, say for Delhi or Mumbai, for instance, resolution plans, they tend to get bogged down because of the multiplicity of IAs that are
Yeah.
still pending. And certain IAs you will have to resolve before you can take a look at the resolution plans. I have had instances where the composition of the COC is still under challenge, but the resolution plan is also pending for consideration. Now, if you decide it in
Yeah.
one particular way, then the entire process has failed now for you. So,
Wow.
the, the certain IAs will have to be necessarily flagged for a higher priority than you have actually been doing. You cannot treat all IAs as the same. So, a triaging system with the help of not just artificial intelligence, though it's a loosely employed term. You need a specialized cadre that will deal with these matters and say these matters will have to be decided before you can deal with certain other matters. Now, what have we designed for this? In order to ensure that it fits into the process, we have designed this process of extension is there, 90 days, but exclusion of certain periods from the CERP
And that's
itself.
how reporting is also being done.
Correct. Now, on an average, it takes 886 days for a CERP to be completed, as against 330
Correct.
at the outmost. So now there is something seriously wrong. You have to probably reimagine the system from there on. The IBC amendments are helping you right now, but that should not become a case of a clerical admission. Uh, there is a little element of adjudication involved even in
Admission
admission
stage.
matters, though not very high. Uh, but those aspects can be separated from the IAs which are hardcore adjudication matters. Reduce the number of IAs which are not required. These can be brought about by administrative changes. Then, if you have multiple benches, or if you have people who have the aptitude for dealing with certain kinds of matters, then create specialized benches. That is the way to go forward. Is, I mean, broadly indicating. We can always drill down to certain other details. Maybe after I hear what Harishji has to say in the matter. But this one is broadly from the perspective of a former member who has been on the bench. Certain matters should not even come up before the members. They should be finished at the registry level.
Yeah.
They should not even be here. So,
So your list looks similar.
You have to decide as an institution how much time you are going to spend on company matters, because as
Bifurcation.
both of us have mentioned that the company law matters are actually being orphaned, right? They're not given priority, and some of them are extremely serious matters, and they're not
correct.
being dealt with in the manner they should be dealt with. So if the NCLT at a as a policy you decide that okay, there are company law benches and insolvency benches, it's not ideal, but I don't have a problem with that. Maybe that's the way forward. Okay, although ideally, if there are two benches in a city, then they should deal with both kinds of matters. What you feel, when there are cities with only one bench, they don't have a choice. But this issue needs to be addressed. That you are still called the National Company Law Tribunal, and company law matters are not being taken up properly in a timely fashion. That's the first issue. Then second is in terms of the organization. Uh, if you are a specialized tribunal, then what is your defining feature, right? What is a defining feature of a specialized commercial tribunal, right? And I think that this is a question that the MCA and the NCLT needs to address. If you are going to be just like the regular courts, then what is the reason for your existence? Right? Then you may as well merge the entire NCLT process back into the courts. So what is your um, unique feature? Right? It doesn't exist. Is it timely dispute resolution? It doesn't exist today. Is it great commercial knowledge, great commercial urgency? It doesn't exist today because people are complaining, and Daksh's own reports say the same thing. So, what is your reason? And you define that. I think we need to define that. Then, if you come down to IBC, I think here both the IBBI and the ministry needs to, the parliament needs to take a call on this resolution plan process. Okay, the resolution plan time. If you look at it, the time given in the IBC for the resolution plan, that's not really the NCLT's problem. That is really the resolution professional and the COC's problem. Correct? They have to, and they have a free hand in that. Because of all the applications that are being filed, the NCLT is being more interventionist than it is designed to be under the code. So that needs to be very clear. At what points can the NCLT intervene in the resolution process up to the resolution plan functioning? You forget about your avoidance transactions, all of those. That statutorily NCLT is supposed to look at it.
Basically, the CIRP stages.
It is supposed to happen. The reason why CIRP is supposed to happen within a time frame is because it's a small window. If you go beyond 330 days or whatever plus 90 plus all the
270 plus
270 plus 90, I'm already being generous. I'm adding the 90 into the into the
330.
first timeline. So because that number, actually, to be honest,
correct.
I've forgotten that number because it's irrelevant.
It's
Nobody even
irrelevant.
looks at it. Right? Because the extension is just given for the asking. So the number is irrelevant. And the moment the Supreme Court said it's only directory, not mandatory, there ends the number. I think from an IBC perspective, and this is not the NCLT's problem in my view, from the IBC's perspective, you need to decide what does this resolution plan mean? Does it mean constant intervention through the judicial process? No, it does not, in my view. In my view, the resolution plan is meant to be that you're appointing a resolution professional who does certain things under the supervision of the COC and examines whether a resolution is possible or not. And why should that be given so many extensions? That is a pure commercial decision, right? And after that, a decision should be made. There's no reason to extend that. If an extension is to be given, that is a serious point. So every extension the NCLT gives has to be not because, oh, I think there is hope. That's not the point. I think, that's the reason why these companies are in insolvency resolution process. The first point, because no entrepreneur, no management believes that he's at the dead end. He always thinks there's some hope to solve it, right? And that's why they're there. So this issue, I think, needs to be solved. And that can't be done by the judiciary. That it is not the NCLT's problem that the resolution plan is not getting done in a particular time frame as was originally mandated. That is the problem of the resolution professionals and the environment around the COC. Okay. The intervention, yes. Whether NCLT has caused to that problem, yes, it has caused to the problem. Added to the problem by constantly, dealing with applications, applications after applications. So maybe there needs to be a moratorium on hearing applications connected to the resolution process for that period. I think otherwise we are not going to solve this.
Correct.
Right? And I don't blame the NCLT benches for this issue because if an application is filed, they have to decide it. That's the problem. Right? They can't say I won't hear it unless the law says don't hear it. See, if a question is raised before a bench, they have to answer it, and that takes time. Right? So I don't blame the NCLT. I blame the design of the
institution
of the IBC process. that if your intention is that the resolution plan, that once the IRP is appointed and then the RP is appointed, a particular exercise needs to happen and needs to be completed within a time frame, which is basically examining whether there's hope to manage this company and make it survive or not. Why should there be extensions given for it? If extension is given for it, there should be a good solid commercial reason, not that the RP did not have time to do whatever he needed to do.
CD is not
That's
cooperating.
correct. That's a failure of the RP involved. And the ecosystem whether we have created an ideal ecosystem for the RPs to function, that they need to make the decision in that time frame. Listen, I mean, we are not the only country doing resolution process, right? What's happening in other countries? In other countries also, is there constant extension? Is it, has 270 become 880? We should examine this. If it's the same worldwide, then maybe then we can be happy and say, okay, we're also
Suffering
just like
from the
everybody
same.
else and leave it. But if we are the only unique standout in this process, then we should find out why we are doing this, right? So I don't think we should conflate. To come back to your question, I've answered it in a long-winded fashion. I don't think we should conflate the NCLT institutional design with the IBC problems, right? NCLT institutional design needs to answer the existential question about the Companies Act. I think, as a company law practitioner, I think all company law practitioners have serious issues with the NCLT not dealing with company law matters. So this is an existential question that needs to be answered. Within the IBC itself, I think there's a design problem of what kind of intervention do you want the tribunal to make in the resolution process, not in the separate adjudication around questions around rights of parties. That's not the point. In the resolution process, are you going to decide rights also? You're not going to be able to decide all the rights of all the parties in the resolution process. The resolution process cannot be a mechanism where you're deciding contractual rights of parties. The entitlement to sit on the COC, I can understand. That's really the only question, in my view, which needs to be decided for the resolution process. You can't decide everything else, during the resolution process. But the law needs to take a hard stand. If you're going to enable this, then you need to leave no doubt as to all these issues. If you leave various doubts, then obviously the NCLT benches have to answer those doubts in every case. Then why blame them for 270 becoming 880 plus 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 plus? You can't blame them. And then, of course, the process we have discussed, but I don't think we should spend time all over again on what kind of process and culture and all of that.
Just again, supplementing what he said with reference to the resolution plan itself, there is again a serious institutional thinking that is required, where if you have given the commercial wisdom and left it to the COC to decide, then it should also be left to the COC to decide its antecedent matters or connected matters. For instance, if they have decided, okay, let's grant an extension of time to people to file though you have an initial date within which you're supposed to file it. If you have not, you extend the time. Now, these are the kind of challenges we get in 60 subsection 5 clause C. Was the COC competent to decide that or not? And now each of these matters, we are all waiting for the Supreme Court to actually give an authoritative pronouncement and say, look, these are not the kind of things you can even challenge. NCLT is wearing two hats.
Correct. That is,
when
I
you're
think,
wearing the hat of
core
the
problem.
adjudicating authority under the IBC, you don't take recourse to the powers that you have under the Companies Act. And certain other procedural matters, like Harishji said, for correcting an order, One can understand if a mistake has been originally committed by one of the parties. One can ask for an IA, say you have the company name, you have a SIN that doesn't match, or the address doesn't match, some copy paste issues, one can understand. But in a case where the tribunal itself has made a mistake, why are you insisting on an IA to correct it? I was told it was because the e-court system will not take it otherwise. But if that is the case, that is a procedural issue that the e-court system must correct.
Has to fix,
You
yeah.
cannot punish the parties by having them file another IA, wait for it to be adjudicated, because once an IA is filed, you have to give notice to the other side now. A corrigendum that could have been done across by just mentioning the matter now will take 1 month. All this adds to the pendency
Timeline, yeah.
and the timeline. Eventually, that is what happens. So, some of these things can be taken care of at the administrative level. Some of them, you have to have a clear vision as to what it is that you want the NCLT to do.
Yeah.
If you have that vision, then probably we can sort it out.
Thank you for listening. That was my conversation with Mr. Rajasekhar and Mr. Harish Narasappa, and you're watching the Daksh podcast. If you enjoyed this episode, do share it on social media and help us put the word out. Find out more about us and our work. Visit our website dakshindia.org. That's DAKSH India.org. Don't forget to tap follow or subscribe us to whatever to where to us wherever you listen to our podcast so that you don't miss an episode. We would love to hear from you, so do share your feedback either by dropping us a review and talk about it on social media. We are using the hashtag Daksh Podcast. A special thank you to our production team at Taper Fox Studios. I'd also like to thank Mr. Surya Prakash and Harshita Kesarwani from the Daksh team who helped bring this conversation to you.